Hi there, I'm Dr. Suzanne Bechtel, a passionate legal educator dedicated to making legal studies clear, practical, and even a little inspiring. On this channel, you'll find a growing collection of videos designed to help you prepare for the Certified Paralegal exam. It covers key topics, breaking down complex concepts, and offering study tips that actually stick. If you're looking for a deeper dive, check out my Teachable School, where I offer structured courses, interactive tools, and exclusive resources to support your journey towards certification. Watch this video to the end and you'll find a coupon code for a discount. Don't forget to subscribe and explore the playlists. Your success on the NALA CP exam starts here. Now, before we move on to the lecture, there are two important disclaimers. First of all, this is not considered legal advice. Everything shared here is designed to support your learning journey. Also, I am not a lawyer. This course is designed to help you understand the concepts of the exam. Hello again. Here we are, officially on the second to the last lecture in the series on debtor creditor law and bankruptcy. Hooray! And the title of this one is Involuntary Bankruptcy, Chapter 7 or Chapter 11. So we'll look at the limitations on filing, the requirements of a petitioning creditor, the filing of the creditor's petition, documents that are filed with the court, significance of filing. There's a gap period here, like we've talked about in another lecture, appointment of a trustee, the creditors during gap period, and debtor's answer, hearing and disposition of the petition, the order for relief, dismissal of an involuntary petition, and ramifications of dismissal. So we'll begin with limitations. An involuntary petition may be filed only under Chapter 7 liquidation and Chapter 11 reorganization. An involuntary petition may be brought only against a debtor who is eligible to be a debtor under the chapter in which the petition is filed. An involuntary petition may not be filed against a family farmer or against a corporation that is not a moneyed business or commercial corporation. Requirements of the petitioning creditor. They must, it falls under 11 U.S.C. Section 303B of the Bankruptcy Code. And if they have fewer than 12 creditors, a single qualifying creditor may file an involuntary petition under either chapter. If the debtor has 12 or more creditors, then 3 or more creditors with non-contingent, undisputed claims totaling at least $21,050 may file an involuntary petition. And remember that these amounts are adjusted every 3 years for inflation. Requirements of the creditor to petition. Claims cannot be contingent as to a liability or subject to a dispute as to liability or amount. So they have to be undisputed claims that are not contingent. The statutory aggregate amount must exceed the value of any lien on the debtor's property. So the debtor needs to be upside down in theory, so that to 20,000 whatever, that must exceed the value of any lien on the debtor's property. After the petition is filed, but before the order for relief, additional creditors may join the petition. The filing of the creditor's petition works like this. They use the forms to commence an involuntary case, but they are slightly different from the forms in a voluntary petition. An involuntary petition is filed with the bankruptcy court clerk's office with the filing fee. The involuntary petition form is B5. Summons is to be issued by the clerk of the bankruptcy court. Keep in mind this is like an adversary action, so the debtor needs to be served. This is brought by the creditor as opposed to all the others which were brought by the debtor. So they were submitting themselves to the jurisdiction of the court. When we're getting to involuntary bankruptcy, we have to look at it from more of a due process, not more of, but due process is, you got to give notice. Got to give them a chance to appear, you got to give them a chance to answer the petition. If the corporate ownership statement must be filed by each petitioning creditor that is a corporation, saying that they do in fact have an ownership interest in the corporation, probably dealing with shares of stock that are issued and that sort of thing, disclosing that information. We'll look at the form and see what that says. So the significance is that an order for relief doesn't come about. There's no automatic, the automatic stay goes into effect, but there's no order for relief until all the elements of the petition are admitted by the debtor or approved in the bankruptcy court, but an estate is created. The gap period is the time between the filing of the involuntary petition and the entry of the order for relief or dismissal of the case. Until the order for relief is entered, the debtor may continue to operate business, may continue to use, acquire, dispose of property as if the petition had not been filed. A case trustee is appointed for Chapter 7 but not for 11, and a party in interest may request the bankruptcy court to order the United States trustee to appoint an interim trustee to take possession of the property of the estate to operate the debtor's business. The debtor who wants to regain possession may post a bond in the amount required, but must account for and deliver the property of the case to a trustee if the order for relief is entered. So the creditors, gap creditors are creditors who hold claims that arise during the gap period. That is, after the filing of the involuntary petition and the bankruptcy court's entering of the order for relief. So these claims are treated as if they arose immediately before the filing. And gap claims are treated as third-level priority claims. So they go down to the third level. If they're unsecured, that can be, it can depend on what kind they really are. But gap claims are placed into the third level to be paid third. The debtor named in an involuntary petition may contest the petition, which is often the case. The debtor may not assert a claim in the answer except for the purpose of defeating the petition. And defenses or objections must be presented in accordance with the federal rules. The debtor's answer, this is an answer can contest the petition. The debtor may not assert a claim in the answer except for the purpose of defeating the petition. Defenses or objections must be presented according to the rule. And in a petition filed with fewer than 12 creditors, if the debtor claims in the answer to the petition to have 12 or more creditors, the debtor must file with the answer a list of all creditors. The list of creditors must contain each creditor's address, a brief statement of the nature of the claim, and the amount of the claim. The hearing and disposition of the involuntary petition. If the debtor does not timely contest, the court will enter an order for relief without a trial. If the debtor does timely contest, the bankruptcy court will hold a trial at the court's earliest opportunity. The order for relief is entered by the bankruptcy court. The debtor is generally not paying debts as they become due unless these debts are the subject of a bona fide dispute as to liability and amount. And within 120 days before the filing of the petition, a custodian is appointed or authorized to and did take charge of less than substantially all of the debtor's property for the purpose of enforcing a lien against this property. Dismissal of an involuntary petition requires the motion by the debtor after notice and hearing or on consent of all the petitioners and the debtor, and can be dismissed by the court for failure to prosecute. Last slide, if it is dismissed, the bankruptcy court can do this obviously, and they could grant a judgment against the petitioning creditors for costs and reasonable attorney's fees incurred by the debtor. If the bankruptcy court determines that the petition was filed in bad faith, the court may award damages proximately caused by the filing and punitive damages as well. So that concludes it. It's just a lot of procedure that goes into it. Fairly simple operation if you got the right quality of the debtor in terms of eligibility. All right, thank you. I hope you got some good information from this video lecture. Don't forget that I have a Teachable school account. Here is the address for that, mayananda-s-school.teachable.com. The name of my school is Mayananda. And also there's a coupon here for you to save some money. And finally, good luck on the exam. And don't forget to like, share, and subscribe.